What?
Silas, can you come with me for a moment? Silas, unfortunately, the company is restructuring. This is your severance agreement, which includes an additional 2 weeks of pay. Your processing isn't delayed. Please sign this and return it to me by 5 p.m. today.
By 5 p.m. today?
That would be best. Otherwise, there may be a delay in processing your payment.
Put that pen down, Silas. That 2 weeks of pay isn't a generous gift from the company. It is the price they are offering to buy your silence, your legal claims, and sometimes even your next job opportunity.
Hey everyone, I'm Silas. Getting laid off is brutal enough, but what's worse is that this stack of legal jargon you sign in a panic could cost you money, rights, and possibly your next career move. Today, in this 8-minute masterclass, we are tearing down HR's psychological read the traps and showing you negotiate for the money you actually deserve.
The first trick is time pressure. HR wants your fear to make the decision before your brain can catch up. But legally and practically, this is not a birthday card. This is a contract offer, and every contract offer can be reviewed, questioned, and negotiated.
So the company is paying me because they feel bad?
No, they are paying you because they want something from you. Poison number 1, general release of claims. This is the core of the severance agreement. Once you sign this, you may be giving up the right to bring claims connected to your employment or termination. That can include wage disputes, unpaid overtime, discrimination claims, retaliation claims, or wrongful termination arguments.
So even if something illegal happened before I was laid off,
You may be releasing your ability to sue over it, depending on the wording and applicable law. Have your him. Doesn't mean every employee has a massive lawsuit, but it does mean you should never sell unknown claims for pocket change before you understand what you are giving up. Reason number 2. Non-compete and non-solicitation clause.
I'm being laid off. Why would they still control where I work next?
Some companies try to restrict you from working with competitors, contacting clients, recruiting coworkers, or using relationships you built during employment. The enforceability of non-competes depends heavily on state law and current legal developments. So don't assume it is valid, but don't casually sign it either.
2 weeks of pay could come with months of career friction? Exactly. 2 weeks of severance in exchange for a year of career restriction? That math may not check out. Poison number 3. Non-discrimination, confidentiality, and quality clawback language. That just means I shouldn't lie about them, right?
But some clauses are written so broadly that even a frustrated social media post, a Glassdeck review, or discussing your experience publicly could trigger a fight. If the company later claims you violated confidentiality, they might try to take back the severance money. None of these clauses are necessarily illegal, but a severance agreement is a negotiation, not a verdict. With enough money and proper legal advice, almost every clause is adjustable.
So instead of taking 2 weeks and a muzzle, what should I actually do?
First, don't sign today. Nothing expires in 24 hours unless it's a legal deadline. Second, ask for the documents. Get everything you need to understand your rights. And third, do the math. You'll be surprised how many people leave thousands of dollars on the table simply because they never ask for more.
But how much more can I actually ask for? I mean, they're already letting me go. More than you think. Severance isn't a gift. It's a business deal.
What is actually worth negotiating? Here are the 5 things you can push for. Number 1, more severance pay. Number 2, extended healthcare or COBA. Number 3, uncontested unemployment. Number 4, a neutral reference policy. Number 5, accelerated velting or bonuses.
If unemployment is basically guaranteed, why would I trade rights for something they'd already owe me?
Exactly. That's why we start with the money. Every extra week of severance you negotiate is worth roughly 1 week's pay. Don't forget to ask for your unpaid bonus too, if you earned it.
The deadline is today to avoid delays.
I understand. Please send me the deadline and any consequences of not signing today in writing. Beautiful. He didn't argue. He didn't accuse. He simply moved the conversation from pressure to documentation.
Important nuance. Some review periods are legally required in specific situations. For example, if you are 40 or older and asked to waive age discrimination claims, federal rules may require at least 21 days to consider the agreement and 7 days to revoke after signing. But even when a specific statutory review period does not apply, asking for time to review a serious legal document is reasonable, professional, and common.
So I should not say you legally must give me 21 days unless I know that rule applies to me.
Correct. Don't bluff the law. Use calm leverage. I'm sure they'd rather give you a few days than have you walk away from the deal. Never negotiate the important terms verbally in a conference room. Use email. Email creates a written paper trail, reduces emotional pressure, and makes every request easier to review.
This is a strong counterover because it is specific, calm, and tied to business value. He doesn't beg. He doesn't threaten. He anchors. They said it's standard. Does that mean I'm done?
Standard is not a magic word. It is often just the first no. If they play hardball, check the scale and structure of the layoff. The WARN Act generally requires covered employers to provide 60 days written notice before certain plant closings or mass layoffs.
So if more than 50 people are laid off, they automatically owe us 60 days?
Not automatically. The details matter. If those conditions are met and no exception applies, what they call severance may actually be replacing notice pay they were already required to provide. Changes the negotiation. You are no longer simply asking, "Can I have more money?" You are asking, "Is this package actually compensating me fairly for rights, notice, restrictions, and legal risk?" This is how you apply pressure without sounding reckless.
Okay, this I can actually review. That is the final lesson. Even when they improve the offer, review the final version. Make sure the changes are actually in the document. Being laid off means this company lost you. It does not mean you lost your life.
Don't be a lamb for the slaughter. Be a player who knows the rules. Knowledge is your strongest card in the corporate jungle.
So, are you ready to learn the rules of the game?
The information provided in this video is for educational purposes only and should not be legal advice, because knowledge is power.
Or a friend ever gone through a layoff? Share your story in the comments below. If this video helped you, please like and subscribe. Knowledge is power. Master the rules, win the game. As we conclude today's legal saga, we invite you to subscribe and like our video. See you next time.